This parliament belongs to those states. It does not belong to Lucky Aiyedatiwa. And the parliament has the backing of the people to carry out its constitutional function. We are saying that the democratic system should be maintained.
We are not saying that the deputy governor, His Excellency Lucky Aiyedatiwa, cannot be impeached. But then, due process must have to be followed.
Mixed reactions continue to trail developments in Ondo, where the State House of Assembly has issued a fresh directive to the State Chief Judge to immediately set up a 7-man panel to investigate the Deputy Governor on the allegations leveled against him. The state's due to failure of the Deputy Governor, Lucky Aiyedatiwa, to respond to the notice of allegation of gross misconduct. I recall that a Federal High Court sitting in Abuja had restrained the State House of Assembly from carrying out the impeachment process against the Deputy Governor, and also restrained Governor Rotimi Akeredolu from nominating a new Deputy Governor. The big question tonight is there an end in sight to this fracas? And what does it mean for the APC in Ondo State? We'll probably get some answers on the show today. Welcome, everyone, to Beyond 100 Days with Nifemi Oguntoye. You can join the conversation right now on X, formerly Twitter, using the hashtag Beyond 100 Days. Remember to tag at TVC News NG. Let's begin with an update this hour. The Ondo House of Assembly has now written a petition against the Honorable Justice Emeka Nwite, the Federal High Court judge who gave an order stopping the impeachment of Lucky Aiyedatiwa, Deputy Governor of the state. The complaint, according to the House, is for compromising his office and violating the extant provisions of the Constitution. Let's get a better perspective from both sides of the divide on the show this evening, beginning with the counsel to the Ondo State House of Assembly, Femi Emodamori. Also joining me is Alan Shore, a human rights lawyer. Gentlemen, thank you for joining me on the program this evening. Starting with Mr. Emodamori, how did the judge in this case compromise his office, and what precisely is your petition seeking?
Sorry, I can barely hear you.
I'm asking how the judge in this case has compromised his office, because that's the content of the petition the House of Assembly has written against him to the NJC. And I'm wondering what this petition is seeking to achieve.
Because number one, you have the provision of Section 188, subsection 10 of the Constitution clearly, unambiguously stating, and I quote, no proceedings or determination of the panel or of the House of Assembly or any matter relating to such proceeding or determination shall be entertained or questioned in any court. No determination or proceedings of the panel or of the House of Assembly or any matter relating to such proceedings or determination shall be entertained and questioned in any court, quote unquote. That's Section 188, subsection 10 of the Constitution. A judge is presumed to know the law, and of course the law is in black and white. Every layman who can read and write understand the law. And so you have this in black and white in the Constitution. You have the Supreme Court again and again coming down hard and look, as long as the House of Assembly is following the laid down procedures in Section 188, subsection 1 to 9 of the Constitution, no court. The Supreme Court is saying no court, including the Supreme Court itself, has the power to intervene.
So then, you are challenging the accuracy of the order coming from this court. I believe that's why you've also approached... Just a minute, sir. I believe that's why you've also approached the Court of Appeal. My question is, how do you disobey one court and then appeal in the other?
Well, you asked me the first question. I'm afraid you have not even allowed me to finish answering that question. But in just to round off on that regard, you have a judge that swore an oath to uphold and defend the Constitution of the Federal Republic of Nigeria. And so when a court deliberately ignores the same provision of the Constitution, creating the court, ignoring Supreme Court judgments on the matter, ignoring Court of Appeal judgment on the matter, giving this order, then you can tell whether he has compromised or he has upheld, the oath of office he took to uphold. And then there are some other matters that, of course, when we get to the NJC, I believe Nigerians will know. That is number one. Then you are asking how you can, disobey the order of a court and appeal. Let me tell you one thing. You have a court that disobeyed the Supreme Court of the law of the land. That is the Constitution. You have a judge that again disobeyed the Supreme Court of the land. The Supreme Law is the Constitution. The Supreme Court again was disobeyed by that judge, and then granting another that is a subversion of democracy, clearly. And then you are saying you should obey. There are two schools of thought. You have the Supreme Court, the same Supreme Court, for instance, stating in the case of Dakan against Asalu, is reported in part 1475 of the Nigerian Weekly Report that, look, when an act is a nullity, it is a nullity, it is void ab initio, it is null and void. The Supreme Court went ahead to say, look, you don't even need an order of the court to set aside such an act that is a nullity in the eyes of the law, although it is sometimes convenient to do so. It is automatically null and void because we cannot put something on nothing and expect it to stand. So now, members of the House of Assembly also swore to defend the Constitution. They took an oath to defend the same Constitution. So if you have a contradiction, inconsistency between the judgment of the Supreme Court, between the judgment of the Court of Appeal, between the express provision of the Constitution and a purported order, I'm sorry to use that language, that's my own constituency.
All right.
But I have got no choice. And then between a purported order of the court,
yes,
which one would they obey? Bearing in mind, please, just let me conclude in 3 seconds, that Section 287, subsection 1 and 2 says everybody, every institution has a duty to enforce and obey the judgment of the Supreme Court and Appellate Court. Institutions in this case include even the Federal High Court, which is subordinate to the two courts. So tell me whether such order is what you think they should obey between such order and the Supreme Law of the land, which is the Constitution. It's a question that
I hear you. Let me bring in human rights lawyer Alan Showore to also get his perspective on this development. I'd like us to begin, Mr. Showore, to explain the basis upon which Mr. Aiyedatiwa approached the court in the first place at the time when he hasn't even been served. The body to hear him is the panel to be constituted by the chief judge. So how do you complain about the violation to fair hearing when the body to hear you hasn't been constituted?
Yeah. Thank you very much. There are foundations to the whole political and legal saga as it affects the surreptitious impeachment plan of the Deputy Governor of Ondo State ongoing. The first thing I will tell you was that the governor returned from Germany on 7th of September. By 12th of September, Mr. Governor sacked all the media aides of his deputy. It's like you are serving somebody a notice. If Mr. Governor had had the power to remove his deputy that same day, he would have sacked him. So, then again, the chairman, House Committee on Information, went on Channel TV, national TV, and made serious allegations against the deputy governor. So you do not wait, you don't expect the deputy governor to wait until his head is cut off before he will approach a court.
But you had your learned colleague making reference to the Supreme Court position on this. I've also had reference made to the case of, just a minute, sir, to the case of Abarebe versus Abia State. I think it was last year when the Court of Appeal in that particular case emphatically stated that it was wrong for the appellant to jump the gun by rushing to the court to stop his impeachment on the ground of alleged breach of fair hearing when the panel to investigate and hear him had not been constituted. It's very clear, isn't it, as to a precedent on this matter?
You are citing a judgment of Court of Appeal. Let me tell you, I can roll out 10 judgments of Supreme Court. But let me tell you specifically, in Amadou Sherry versus PDP, the Supreme Court clearly stated that the party serve with an order of a court of competent jurisdiction, does not even have the luxury of choice to say either you will obey it or not. You simply obey. It is funny when you see lawyers who graduated from Nigerian law school who say that an order of court, because it has always been the law, even when the judgment is perverse, you have to obey it. You have the option of an appeal. And I'm surprised because the same set of people, if you follow the trend, they petition the judge who granted this order to NJC, they have equally appealed the same judgment. A man who does not believe in the judgment of court has equally gone to appeal the same judgment. So why are they rushing? What is the desperation? In Ondo State, as we speak, the question all the cities, the good people of Ondo State are asking, where is Mr. Governor? We don't know the whereabouts of Mr. Governor, and you want to remove the deputy governor. Why are you in haste?
All right. I think you've asked a very critical question, and I want Mr. Emodamori to respond to that. Why are you rushing? Even you have gone to the Court of Appeal because you disagree with the judgment of the High Court. But is the House now not positioning itself as being above the law in disobedience of that order?
Let me quickly answer this question. The Ondo State House of Assembly, my client is not in a rush. They didn't rush to court. In the case of Abaribe against the Abia State House of Assembly, which you cited, and that is precisely in pages 506 to 507 of the judgment, the Court of Appeal said, look, rushing to court to allege breach of fair hearing, even when the panel that will hear the allegation against you has not been constituted, is an aberration, and that you have no right to protest at that stage. Now, we didn't go to court. His Excellency, the Deputy Governor, went to court, rushed to court. So who is rushing here? The House received allegations of gross misconduct, and you have 14 specific allegations in that notice, some of which, like I've said repeatedly, contain allegations, of course, allegations, in quote, of financial impropriety running into hundreds of millions of naira. In one, you have 500 million naira diversion of local government fund while His Excellency was the acting governor. In one, you have 100 million. In one, you have 200 million collected, allegedly collected as bribe from traditional rulers who wanted to be upgraded. Of course, the office of the deputy governor supervises the Ministry of Chieftaincy and Local Government, and then there was recent upgrading of some traditional rulers in Ondo State from minor chief to recognized chief, which is Oba. These are allegations. You have allegation that he collected about 5.4 million naira to buy tire for a vehicle. I don't know. I know there are armored vehicles, but I'm not aware of armored tires. There are allegations that he collected 2.6 million naira to travel from Akure to SLD. 2 hours journey, 2.6 million naira. And then the House has said, look, these are serious allegations, and that by virtue of the provision of Section 15, Subsection 5 of the Constitution, the state has a duty to abolish all corrupt practices and abuse of power. Sir, could you please explain this? Mr. Speaker received the allegation on 20th. His Excellency, my own very good friend too, rushed to Abuja on 21st, even when the Constitution specifically states that he should be served within 7 days. And I'm talking of Section 182, Subsection 2, Paragraph B. He rushed to court.
I want us to, we understand, just hold on a minute. I understand what you're saying, and I think we've moved a little past that. We understand what happened. But I also want to bring your attention to what transpired in Zamfara. You know, I think it was in 2021, thereabout, when the same step the House is taking now was taken by the Zamfara State House of Assembly when it was restrained by the court from proceeding with the impeachment plan of the former Deputy Governor Gusau. Now, this is what the judgment said. It says it was wrong of the respondents to carry on with the purported impeachment of Gusau while the matter was still pending in court. It goes ahead to say that it is not permissible for one of the parties to take any step of complete helplessness or which may give the impression that the court is being used as a mere subterfuge to tie the result of litigation and the appropriate order of court before acting further. You know what happened thereafter? The impeachment was voided by the court. It was called illegal and unlawful, but unfortunately, that was after the tenure had expired. Don't you think that we have a lot of precedents in this matter as regards when an order is given by the court?
Can I answer your question now, please?
Absolutely.
Thank you very much. Every situation is treated based on its own, particular merit. The case of Sanfara is quite different. Now, if you go back to the Supreme Court very exhaustive decision in Nakojo against Adeleke, and you have many like that against following, that as long as the House is following meticulously the provision of Section 188, no court has the power to intervene. Courts have indeed intervened in previous occasions, here and there, and most impeachment in Nigeria, because those provisions were not being meticulously followed. Let me say with all pride that this is the first time a House of Assembly has taken its time, meticulously complying with the provision, waiting till the last date of every stage before taking action instead of rushing any proceedings. They collected, they served. They waited till the 14th day, for instance. Abaribe's case, you don't even need to wait till 14 days. The 14 days is the period within which you must move the second motion, calling for investigation panel, but that you can move the motion even before 14 days. In this case, my client had to wait till the last day. Mind you, every stage in the impeachment process is time-bound. You must serve them within 7 days, they serve within 7 days. The second motion must be moved within 14 days. Should my client wait for the constitutionally stipulated period to expire? The answer is no. And then Mr. Sowore, my very good friend, said something. Let me clarify that on this program. Up to today, my clients were never served the purported order of the Federal High Court. I mean, when you serve orders, there are proof of service. They leave the posts to affidavit. I served them on so day. You know what they did? I don't want to accuse anybody of anything on this program. They procured the purported order, kept it in their file, thinking, okay, just serve whoever is supposed to constitute the panel. They didn't even serve us, as I'm speaking, my client, the originating process. Their intention is that when you come to court and say, I've not been served, we'll say, okay, it's the fault of the belief. They will serve you. You will take date for adjournment. You come back and reply. They will say, I've just been served. The intention of these cases is to stall. But like I said, you have constitutionally stipulated period within which certain things must be done.
Let me bring Mr. Sowore in to this conversation because we have a very limited time. I'd like us to explore the merit of these allegations. You heard him talk about armored vehicle, armored tires, and there's a long list of 14 allegations here. Don't you think the deputy governor should be eager to also clear his name rather than asking the court to intervene in the process?
Yeah, thank you. The deputy governor is very, very much willing to clear his name. But like I told you, he's a law-abiding citizen, second number 2 citizen on those states. So he will not do anything to, disregard, disparage, and ignore a valid and subsisting court order. But let me quickly react to some of these nebulous, unsubstantiated, and very ridiculous allegations against the deputy governor. We know what is playing out. You accuse a deputy governor of issuing press statement against the governor. Where? Which channel? Is it in the move? You accuse the deputy governor of dividing the head school. If I may ask, which of our law book regulate a political conduct? You accuse the deputy governor in the first instance. They say he approved 300 million naira on national TV. And when eventually they came out with their charge sheet, the 300 million naira for armored vehicle was missing because they knew there had been issue. They were lying against the man. You accuse the deputy governor of embezzling or diverting 500 million naira from local government. Don't say we have ministry of local government, we have chairmen. So you just come up with this allegation without evidence, just to call the dog a bad name. You are, those states, I know the man who is in charge of procurement, who will ensure that no item is purchased above the market value, is the son of the governor, PPMU, the Director General of PPMU. And you have an engineer who will go out, I don't understand, to check if there are problems with vehicle. Are you now saying that the deputy governor is responsible for buying tire? Have they reduced the office of deputy governor in Ondo State to mere civil servant? That again, you accuse the deputy governor of embezzling the money he is supposed to use to travel. I was essay to the governor, and I know some of these things. The money that is meant for the journey of a governor or his deputy, they don't see it. They are handled by protocol officers. The protocol officer will go and buy vehicles, fuel for the convoy. They will give the police, the press people, the allowances. When I was with the governor, I was essay. I collect 20,000 naira if I travel out of Ondo State, and I am supposed to sleep in an hotel that worth 15,000 naira. All of this, the protocol will be in charge. But you are here coming to accuse the deputy governor of spending basically the money meant to travel. The deputy governor that is inside a vehicle, while the protocol officer will make arrangement, you have advanced team who will go carry security and scan where it's going to sit. You have people, the police, who will ensure that there is security of life. Even if eventually such journey were not carried out, it is the officer who will return the money to the vault.
I hear you, Mr. Showore. I'm afraid that we have just 2 more minutes to go, and I just want to get a closing remark from your learned colleague. The APC has now set up a 9-man committee to intervene in the impeachment crisis rocking Ondo State. The objective of the Aminu Masari-led committee is the peaceful reconciliation of all parties involved. Is that something your clients are open to?
Please, for 3 seconds, let me first answer some part of the observation raised by my very good friend, Mr. Showore. He's talking about allegations that probably he read in the social media. Those are not the things contained in the 14 specific allegations before me. And that is the danger. You rush to court based on social media reports. Then let me just quickly answer your question. Just let me quickly answer, please. No, please, they gave me the time. Please, my very good friend, let me just quickly answer. Now, you have free loud the defense for the governor. Beautiful, fantastic, captivating. Why is it difficult for the deputy governor to now present this defense before a panel instead of saying, please don't investigate me? I mean, the wicked flees, in my own opinion, when nobody pursues. The righteous is as bold as lion. This beautiful defense, Mr. Showore, I know you are one of the best. Why don't you put it together and appear before an investigative panel, including allegation that he collected millions of naira to travel that he never did? These are allegations, I agree. And that is why it should be investigated. For somebody to rush to court say, don't investigate me. Don't you think something is wrong?
Mr. Amodamori, are your clients open to a political solution to this problem?
The APC committee, as far as we are aware, is to reconcile the deputy governor and the governor. This is a legislative affair, and it has to do with corruption allegation. I'm afraid if APC will come and tell Nigeria, for instance, that look, please cover up corruption allegation, there will be a problem in Nigeria. Right. My clients for now have no reason to stop what they are doing. They are continuing, I can assure you that.
That's your time. Mr. Showore, you have 1 more minute for your closing remark.
If we have a state House of Assembly that is responsible, with due respect, the first thing they have to investigate is the 27.8 billion oil windfall released to Ondo State. Is that 4.3 billion kept in secret account that was discovered 10 years after? Those are the weighty allegations that is required to be investigated. And the most important thing that I want to ask in all of this, because we are stakeholders in Ondo State, we want to know the whereabouts of Mr. Governor. You cannot be hiding the governor, and at the same time, you are planning to remove the deputy governor. Do you want to cause constitutional crisis in Ondo State?
All right.
What is driving this motive? What is in your intention? You cannot be hiding the governor for us, and at the same time, you are planning to remove the deputy governor.
I think that your point is made, Mr. Showore. Thank you so much for your contribution. You've asked that question twice. Perhaps when we continue this conversation, we'll be asking Mr. Emodamori where Mr. Governor actually is. But a big thank you, gentlemen, for joining us on the program today. Counsel to the Ondo State House of Assembly, Femi Emodamori, and also Alan Showore, human rights lawyer. Thank you for sharing your thoughts with us.
My compliment to my very good friend, Mr. Showore.
Thank you, bro. Senior colleague.